Good afternoon, one and all present here. My name is Vandana Chaudhary, final year student of 3 years LLB course. I feel so privileged that respected ma'am has given me the opportunity to speak for this wonderful 10 days internship program. And today it's the first day of our 10 days internship program. So we all are delighted to have such an eminent person with us who has a dynamic legal experience of more than 21 years. And now I take this prerogative to introduce our guest speaker to you all. Respected ma'am started her practice from Andheri, Mumbai Metropolitan Magistrate Court. For 5 years, she had done juniorship, which made her full-fledged in trial courts. Later, ma'am got exposure to matrimonial disputes, where she did excellent work and known as one of the leading lawyer in resolving disputes with her excellent work and known as one of the leading lawyer in resolving disputes with her enriched experience. Later, after 12 years of her practice, went to Delhi. Ma'am studied and practiced in Supreme Court for 2.5 years and cleared advocate on record exam of Supreme Court. Ma'am have been practicing before Bombay High Court and appeared before Nagpur bench as well as Allahabad High Court, and since last 6 years have experience as an advocate on record of the Honorable Supreme Court at New Delhi. Not only this, recently ma'am has been appointed as the panel lawyer of Employee State Insurance Corporation in Bombay High Court. Ma'am have taken large number of bails from Honorable Session Court and have done criminal trials under the Indian Penal Code, Copyright Act, Tree Plantation Act, MRTP Act, Information and Technology Act. Ma'am have done endless 138 cases under Negotiable Instruments Act. Ma'am have done more than 2,000 matrimonial disputes in Bandra Court, Thane and Panvel. Ma'am have also appeared in DD Sayadri many times in a live question answer session on burning issues of Nirbhaya as well as other women related matters. Ma'am have done programs on All India Radio on the subject of RTI Act and laws against terrorism in our country. Ma'am have also written for a magazine published from Chennai, namely Indian Age. Ma'am have been called as a speaker in many Rotary Club, Radio Club to speak on women's laws. Ma'am is also coming out very soon with a book on legal drafting for juniors. So now over to you, ma'am.
Thank you.
Thank you, ma'am.
Such a lovely introduction. You really did very well. Thank you so much. Vandana is also one of the students amongst you, and I'm very happy. She did it really well. She has been attending my lectures of Saturday day also. So now, internship is a very deep subject. Though not a legal, I would like to tell you, all of you, see, it's not a question of legal or illegal or whatever it is. Just have the spotlight for all of you. So those who have made an efforts to join today, I'm thankful to them. And let me tell you, you have chosen a very good career option. And this career option will always help you to move ahead in the life. And I would like to tell you all, see, this legal profession is not only related to your career option. It socially also you can help so many people, and you will grow in social life as well also. Also, you can help so many people with your knowledge. See, knowledge is power. Now, career option as a legal profession, why people choose it? To only to earn money? No. See, we call it noble profession. The reason behind we call it noble profession, because if you see nowhere the fees term is described anywhere in the law. It may be 1 rupee or it may be 1 crore rupee for any lawyer, but you will never find the fees is described anywhere. And it is called a noble profession to help somebody. तो जो विद्वानों का प्रोफेशन है हम किसी को हेल्प करना चाहते हैं, and help in the sense what we are helping people to get resolve their dispute. Now there is a criminal law as well in this. In criminal law, somewhere we are also representing the accused side. Then there is a question arises, how when we are appearing for accused side, how come you are in a noble profession? Now let me tell you, every crime is committed due to some circumstances. When these circumstances are beyond his control, beyond her control, it may happen. I will give you one small example of an accident case. Here in this, it's a very painful story. I was in Andheri court and one senior lawyer was there. He was representing the accused lady. And when I sat there, I heard uh, the story was that facts of the case. The mother was taking reverse in the car, and this child 2.5 years was behind. And the father was telling her, you, the father of the child, he was giving direction. The mother reversed the car, and child was thrown beyond. It was very painful, and the child was killed. When the matter came up before the trial court, the judge argued. Of course, the father was there as a witness. She was herself was broken because she lost her child. Then the lawyer argued he was a senior lawyer, Mr. Patankar from the Andheri court. He argued very well that she has already been punished because she lost her child in that accident case. And it was not because it was sheer negligence. Why accident cases are about negligence? It is because accident is accident. It is because of nobody does it purposely. In this case, when this matter was argued, she was punished, but this fact was recorded in the mind of the judge that she did not do it purposely. It was her sheer negligence, and even the person father who was giving a direction to come reverse the car, he was also equally responsible. So they have already lost the child. What the court will punish her? She has already been punished by in the form of nature by because of her own negligent act. So in criminal law also, we are representing the accused, but we have no idea about the circumstances he or she must have gone through. There may be a reason of poverty, and people may go and they become a thief, but that does not correct them the situation. But then it is our duty that to teach them. Or when see whenever the case is over, I try to always to sit with the clients and tell them this is not right. You should change. If it is a matrimonial dispute and the person is very aggressive, I tell them this aggressiveness may have brought your relation to this stage where you have come to the court. If it is a criminal matter, there is some murder or half murder, or there is some battle between they are battling with there is weapon use. I tell them, see, weapon is not something you just pick up and stab somebody. No, no, that is not our job. Our job is to give birth. See, as a human being, there is a procreation. The procreation of the human being is done only through where man and woman meet together, and there is a marriage. So many things are there. So, and when you take up career as a law, always trust me, there is no end to it. There is no retirement age. Of course, there is a beginning age. Once you get an LLB degree, at any age you can start. And you can work till 91, 100, whatever age you live. Recently, I came across a newspaper item where a 99 years or probably 91 or 93, above 90, he was online. He was attending in the Rajasthan High Court, he was attending the online session of the courts. So see, such a commitment from this dedication from the senior lawyer. I will try to share that screenshot is with me. So legal profession is very good. You can come anytime, you can go anytime. Also, if you are unable due to some reason, you can always send a friend. There is a very good term in legal parlance, that is amicus curiae. Amicus curiae का मतलब होता है कि कोर्ट का दोस्त. But I would say every law is amicus curiae. वो is a friend. If you want to help somebody, you can always help somebody. And you never know way you will help. See, lawyer's job is not only going to the court. You can counsel your clients. You can tell them what to do, what not to do. Sometimes with the matrimonial disputes, the clients come to me. I tell them these are not the reasons you should go for divorce. So it is very different arena altogether. So I welcome all of you in the legal profession. And trust me, if you work hard, there is no looking back in this profession. You can go on till whatever age you want. You can devote whatever time you want. And for women, especially here, I would like to tell also all of you, if you are coming to this profession, if you are married, unmarried, if you shift to some other place after marriage also, You will find court at every place. And even if you are going out of India, also there are courts are every place. So you can always practice. And the rules of the evidence or the criminal procedure code or civil procedure code are one or less same everywhere. So wherever you go, you will find the court everywhere. There is no chance that you will not find a job. Only thing, there should be willingness to learn. If you are willing to learn, you will find everywhere the courts, everywhere the lawyers, and the lawyers will be more than happy to keep you if you are hardworking, if you can add value to your juniorship. In my juniorship, I remember I used to read each and every page and every word, and I used to ask the surrounding lawyers if my senior was not available, what is the meaning of this? In fact, I tried to go early in the court, 1 hour early in the court, and leave when the after the judge left. The reason I wanted to be in the surrounding vicinity to understand the legal things. So if you devote more time, trust me, you will be at the scale of the height where you can find Ram Jethmalani sir and some other big lawyers, Hari Salve sir, Gopal Subramaniam sir. I respect so many. Indu Malhotra madam. She became a Supreme Court judge. I have shared her interview in the chat box also. So if you see, there is no end to this. You can become Supreme Court judge as well. It's not a question that you are not strict to the up to only to the that you can only be a lawyer. You can be a prime Supreme Court judge also. I have also given shared one video of the Dhananjay Chandrachud sir. If you see, that's how humble he was speaking. So there are some qualities which we should learn. We should keep our mind always full. Try to listen. Be a good listener. As a lawyer, our job is always to speak. But if you listen, I'm sure you have to speak less before the court. If you ever observe, there are two lawyers in the court. You feel if they shout, if they argue loudly, is the judge going to give them order, favorable order? No. The judge gives to the favorable order the person who speaks to the point. This is my experience, and who speaks less. If you argue more, if you argue with lot of doubts and lot of loudness, the judge understands she or he does not have good material with them. So always remember, the first quality of a lawyer is humbleness. The second, I would say, you should have a very good knowledge, and you should know your case. And how you will know the case, we will unfold all these things in the coming session. We have 10 long days journey to go. Now, about the profession, two, three things I would like to tell you. First, try to read as much as you can. Luckily, you are born in an era where there is a lot of material available on internet. However poor you may be, but getting a Wi-Fi connection, even from the outsiders or your neighbors, is not difficult. If you request somebody that I want to read a book, you can download a book. If you don't have laptop, at least you have a cell phone in your hand. Or you can request somebody to borrow a laptop and try to download the judgments of few good judges of the Supreme Court and the High Court, and try to read each judgment, one judgment every day. If you read one judgment every day, trust me, your language will improve. You will have a lot of knowledge. And once your language is improved, the people around you in the court will understand that you have a lot of good knowledge, and people will pick you like of this. I have remembered people have asked me, how do you got to this? How do you become Supreme Court lawyer? Only one thing, one secret, nothing else. That one secret is that I kept on reading. I kept on reading. Till date, I am trying to put 4 to 5 hours every day, apart from the regular reading. It may be to give a session, it may be to write an article, it may be to study for my cases, or it may be from the legal language, or to improve my legal vocabulary. And your legal vocabulary will improve if you start reading judgment. And it's a big ocean. There are thousands of judgments. I need not buy a book. On internet, judgments are available. There are some good sites. SCC online and bar and bench, live law. They may not give you complete control over the website, but the Indian Council is giving completely control. You can read whatever judgment you want. So the material is available at your stage, and you have to just go through this. And whenever you find it's not necessary, you can read it either in the morning, after lunch, late night, but study. That is the key to your success. Now, I will discuss as a part of internship one small judgment, that is Arnesh Kumar versus State of Bihar. It is 2014 judgment of the Supreme Court. Now, Arnesh Kumar's judgment is on anticipatory bail. This Arnesh Kumar wife lodged an FIR under Section 498 and Dowry Prohibition Act. His bail was rejected, that is anticipatory bail, by the Session Court and the High Court. Then he approached the Supreme Court. Now here I will add one more thing. Anticipatory bail power are given only to two courts, that is Session Court and that is High Court. After High Court, if it is rejected, you have to go approach the Supreme Court. When it goes to Supreme Court, there is no anticipatory bail provision. Every order is challenged in the form of SLP, that is called special leave petition. Now, this special leave petition, when it came before the Supreme Court said that for anticipatory bail in 498 matters, if all the clients come to the Supreme Court, there will be floods of the cases. So how it will happen? Now, this is a landmark judgment of the Supreme Court which says 498 cases as well as punishment wherein up to 7 years need not be, the accused therein named in the FIR need not be arrested. See, this is a very important point. What is the base of this judgment? This judgment says whatever may be the offense, where the punishment is up to 7 years. It may be non-cognizable offense. It may be cognizable offense along with non-cognizable offense. Also, Dowry Prohibition Act or any offense where the punishment is up to 7 years. The accused need not be arrested, those who are named in FIR. Now, this matter was particularly related to 498 matters, obviously for matrimonial dispute. There were some allegations. As he did not get a bail in the High Court as well as the Session Court, he has approached the Supreme Court. When the Supreme Court heard this matter, it went to the CRPC, Criminal Procedure Code. Now, there is one section in Criminal Procedure Code, Section 41A. Now, Section 41 is a big section where many subsections are there. When you read Section 41, it speaks about arrest, how a person can be arrested, and there are some guidelines about this. Now, when the court went through these guidelines, there is a section of 41A CRPC. Now, 41A is capital. Now, when 41A CRPC is used by the police, they need not arrest a person. Whenever an FIR is lost, where the punishment is up to 7 years, they have to issue a notice to the people named in FIR within 15 days after the FIR is lost, to call them police station for investigation, for recording their statement, to say their side, whatever evidence they may have. There may be false complaint as well. Now, 41A CRPC notice is given, and the notice is complied by the accused people, those who are named in FIR, and they come to the police station. Then it need not necessarily, police need not attend, need not arrest them. So what happens whenever 41A CRPC notice is given, the police will not arrest you. But if you are not complying with 41A CRPC notice, then police can arrest you. They can give a reason for arresting you. Now, because of this judgment, what happened? All the guidelines were drawn into this, and court made some observation, and throughout the country, the message was sent loud and clear that under 41A CRPC notice has to be given whenever there is a punishment up to 7 years. The police officer has an obligation to call the accused, record their statement, and not to arrest them. And going for anticipatory bail or not is the accused choice. He need not arrest them, make an investigation, file a charge sheet before the trial court. Now, whenever this, you will find around people, you will say, police has called me. People get afraid. See, this is a colonial laws, IPC, CRP, Evidence Act. Though there are amendments, we have all derived these laws from the British. Now, we are following out British rules. See, British were ruling India. So, there was always a fear. Whenever we saw police, there was a fear. And this situation has not changed. The court, so therefore Supreme Court, to vitalize that CRPC or the law is to help people to get justice. And this 498 matters, matrimonial disputes, when 498 was brought into the IPC with amendment, was only to help the women against the harassment by the in-laws. But what happened? Some women started misusing these laws. That's why 492, you will always find that people call it draconian law, that all the in-laws and husband will put behind the jail. There are sometimes grandparents were also put behind the jails. There are possibilities that married sister, unmarried sisters, they were also put behind it, though they had no role in harassment of that lady. And because of this, there were a lot of 498 matters all over throughout the country. And with this law, some ladies used to misuse this. And I would say they would, some were frightening the in-law that if you do not listen, if you do not pay me good alimony, if you do not give me divorce, I will file a case under 490. And this case is a landmark or milestone judgment which put a bar on it. Somewhere it can control. There came in check and balances. And because of these check and balances, now if you see 498 matters, still I get clients who say 498 law jo hoga to humko jail mein jana padega. So I tell them, you read this judgment. So from today's session, even if you take up this from me, the Arnish Kumar versus State of Bihar 2014 Supreme Court judgment. It's hardly 5 to 6 page judgment. You will require 25 minutes to read it. And if you can share with these people around you, it will be a big help. And trust me, the court has put a note on this. They hasten, the judges said, we hasten to put adding here. It is not only for 490 or matrimonial dispute. 41A CRPC notice has to be issued in every offense which is registered in police station against whatever the charges other than 490 also, that they will not be arrested and they will be guided that if you want to go for anticipatory bail, you can go. However, I found a line in this that anticipatory bail is not compulsory. They should only comply with the police officers' notices, and whenever they or police calls for the investigation, they should comply. If at all police want to arrest, then that time they have to record a reason for such arrest. So this is very important judgment. If you can read, it will help you. And not only to you, that's why I said it's a noble profession. You can help so many people, but then the choice lies to you. See, law is a power. Knowledge is a power. Now, these three words goes together. And if you know have the knowledge, knows the law, then you can help so many people. That is the social obligation of every lawyer, including me. Now, this session was also conducted to make aware. And if you can make aware one lawyer who are coming to this profession, I can make so many people aware. And through you, you can always get more people in chain. So this is one judgment you should read that I would call homework for all of you for today. Now, moving to another subject for today. You must all have heard difference between NC and FIR. Now, NC, the full form is non-cognizable, and FI is first information report. Now, you have always heard कि मराठी में बोलते जाऊन एनसी लिया, एनसी लिखवा दूं क्या मैडम? थोड़ा सा भी झगड़ा हो जाता है, ये मुझे डर लगता है. See, NC is about non-cognizable offense. आपका छोटा सा बातचीत हो गया किसी से, और किसी ने आपको कुछ बोल दिया, मैं आके आपको मार डालूंगा. दिस इज ऑल्सो ए कॉग्नाइजेबल ऑफेंस, मारने की धमकी देना, लेकिन उसके हाथ में वेपन नहीं था. तो 506, 50 पार्ट 1, पार्ट 2 आप रीड कीजिए आईपीसी में. बट आई विल टेल यू ऑल ऑफ यू, it's not necessary that every time you go to police station, police will take an FIR. They will try to take NC if it is not a very serious offense. So NC is not about very serious offense. It may be a small confrontation between two people. They are in conflict. It may be a मराठी में कहेंगे कि पड़ोसी का जो झगड़ा हो गया है, चाळीत एकमेकांशी भांडण झालं, or there is a whatever, even husband and wife differences sometimes goes to a level where the wife goes to police station and police try to take first NC. Now NC, the police officer have no right to investigate. In fact, he can't even call. But then police officers calls and people goes. And it is more for to create a samjhota between the parties, to patch up the people. And in future, see why you have to record NC. In future, the matter goes out of hands. This NC will be record. But always, I always tell clients, don't go for recording, creating record. That is also not good. Police station is not something where you should go often. It is not a place where you should go and uh, bombard the police station of your personal fights between the families or some small tiny matters. You should always go to police station when there is no other alternative. First, try to resolve it, and that is a rule applied if by every lawyer there will be less cases and less pendency throughout our country. And that is your one job. As a lawyer, always remember it is your first job. You should not be pro litigation. You should tell people resolve between yourself. If it is not resolving, come to lawyer. If lawyer also can't resolve, then if you have no other alternative, then only you have to fight a case. This is what I've been telling in civil matters and matrimonial dispute to my client, and try to resolve it amicably. That is a good solution for everybody. And if you are unable to resolve amicably, then of course courts are there. When then court has take its own study time, because there is a lot of pendency in all the courts. There is also a lot of vacancies for judges which are not filled up. That is another administrative problem. So here some are the future judges we are finding. So if you want to become a judge also, it is your first duty to tell the people to amicably settle. Now you must have heard there is a concept of lok adalat. Lok adalat says both the people can come together and sit down and sort out the matter. In civil matters, I've been informed now there is a compulsory lok adalat matters, and both sides are made to sit together, and they are asking they are asked by the lawyers on both the sides and also a neutral person of the court to sit down and sort out the dispute between them. Now this helps a lot, and somewhere we are helping the courts, or as a lawyer, our first duty to help the court to reach a justice. And when court can give justice only when there are less case and court have time, ample time. Otherwise, the court, see, you must have heard justice delayed, justice denied. Now, why justice delayed? Because there are more cases. Even judges are loaded with lot of cases. Now, for every judge to read 50 matters a day is next to impossible. Every judge to remember each and every matter and what is the issue in that is also next to very difficult. In such time, if you can help the courts as a lawyer, upcoming lawyer, that you resolve the matter in your own chambers, in your own office, then it will be a very good idea to help the country also and the overburdened system of the legal system. We have 8 more minutes. I'll speak about the anticipatory bail also. Now, anticipatory bail is a one legal term. एंटीसिपेट करना, यानी आपको मालूम है कि आपके अगेंस्ट कोई ऑफेंस रजिस्टर हो गया है और आप यू आर एंटीसिपेटिंग दैट यू विल बी, यू आर एप्रीहेंडिंग कि अरेस्ट इज देयर, यू आर एप्रीहेंडिंग अरेस्ट. Arnish Kumar is on anticipatory bail. So if you read the judgment, anticipatory bail is a pre-arrest protection. When bail is granted, once you are arrested. But if you are not arrested, if you come to know ever that police have filed a case against you, you have every right to approach a lawyer and go for anticipatory bail. Now, anticipatory bail, as I said in the beginning, only 2 courts have power. That is Session Court and High Court. First, you have to approach the Session Court, then High Court. Now, this is a protection. Now, anticipatory courts, whenever you take up, you should always bring out the true facts to the court. There is a possibility there is a false complaint lodged against you. Now, you need a protection. Now, why anticipatory bail came in the CRPC? The reason behind that, there is a possibility when baseless cases are filed and police comes and arrest you, the people lose their reputation. It's a humiliation, trust me. When people are arrested by police, it's a humiliation. It may be old people, somebody is sick, somebody may be having children, somebody may be having a heart problem, his health is not good. So anticipatory bail is the reason where you can be given a protection from the arrest. And when you're given from the protection from the arrest, nobody can arrest you and you will still be going to the police station giving a statement without any fear. So anticipatory bail is one relief. In a criminal practice, every lawyer should know 438 CRP is this section, and there are very good judgments on it. I have enumerated all these judgments in one of my video on the YouTube. If you go through this, you will find lot of judgments also. Ernest Kumar is one judgment such, but it is a milestone judgment which is saying about the guidelines of the arrest and about the anticipatory bail. Guru Bakh Singh Sibia is the one. It's a, I would say, anticipatory bail ka queen Raja hai. Matlab, if you read that judgment is cited so many times by Supreme Court and all the high courts and the other courts in their orders. So Guru Bakh Singh Sibia is a very good judgment. If you read it, you will really get what is anticipatable. It is discussed very nicely in that. So this was all about. Now we can have interaction. Thank you very much for giving me patient hearing. And before I will ask Vandana to start interacting with the children. You can put your name. Vandana will announce the name. Then you can come. Otherwise, it will be chaos. So you can unmute yourself. When Vandana calls you, you can write in chat what questions you have.
Participants have any questions, they can on the video and write your name at the chat box.
Vishnu, you can unmute yourself. Vishnu, you can unmute yourself. I've given the option that you can unmute yourself. Where?
Okay. Good afternoon, ma'am. My question is regarding CRPC 41A notice. Suppose a person has been arrested in theft case, because in the theft case the punishment is less than 7 years. It is cognizable and non-bailable offense.
Right.
So if the police arrest in cognizable case in which the punishment is 7 years or less, so what should we do?
See, normally in 41A, wherever 41A notice is, now we are talking about death case. Now you have to find out that person is continuously, he is a thief. There are pending cases against him. In those cases, see, 41A notice is not very absolute notice. Up to 7 years, police can always give in 41A notice, but it is a thief. Then there must be some reason. Because in such kind of, it is mostly for family matters, civil disputes. But then there is a blanket for 41 notice. If there is a thief and he has taken away, stolen something, which is very important, and there are other surrounding section also you have to do. Only is 379, 380. Just find out. So it is not something very social. It is anti-social. The police may not give 41A notice, but then they have to record reason for that. That is an offense of very serious nature. The way the offense has committed. There is one matter in mostly in 490 matters, anticipatory bail is granted, but Gujarat High Court matter is there. I think the accused name is Mayan, in which anticipatory bail was refused because they have beaten up the daughter-in-law in such a stage that she lost her own pregnant child. She was pregnant, she lost her child in the home. So now you have brought out a case of thief. Now here, the way he has stolen and why he has stolen, there may be reason. In such cases, police will be little suspicious and they may not give. They will want to find out want to find out whether there are past cases against him, or he may be a regular thief. That is the reason 41A notice may not be issued in such cases.
Okay, ma'am. I have another question also.
Sure.
You referred about non-cognizable offense. So,
Yes.
in cases which are not serious, in such cases, police register NC. So,
Right.
what happens after the NC is registered? Does police go further in doing investigation, or?
I have answered it. I will re-answer it during this session. See, in non-cognizable offense, police have no right to call you to the police station, and they cannot investigate. One. But because of the fear, people go to police station. One. Number two, NC, if the police wants to investigate, they have to obtain written permission from the magistrate in those kind of cases. So always remember, in NC, police cannot investigate. It is just a matter of record that this thing has taken place. There may be a small fight between the brothers, among the neighbors. There may be children playing cricket, and then car ka shisha toot gaya. तो जाके एजेंसी लिखा देते हैं. तो जरूरी नहीं है कि in those kind of cases, non-cognizable offenses, the police will call you, and even if they call you, they will try to patch up. They will cannot investigate in such kind of matter. But always remember, NC can be converted into FIR if the offense goes ahead. Okay.
Okay, thank you, ma'am. Last question, ma'am. You have told one case law regarding anticipatory bail. Another case, something Gurmit or
Guru Bakh
something.
India, Guru Bakh India. I have a video on that, on anticipatory bill, detailed video. I'll put in the group today. Okay.
Okay, thank you, ma'am. Thank you so much.
Next, Anand is having question. Vandana, keep yourself unmute.